There's been some discussion about a new provision that was not in the filed version of the bill.
Say it again. I'm sorry.
There's been some discussion about a new provision that was not in the filed version of the bill. If the claimant or relator, the person who brings the lawsuit, is not related to the person who sought or used the drugs, that person is entitled to 10% of a minimum of $100,000, correct?
If they're the relator, yes.
Are you concerned about that creating sting operations, people like creating scenarios just to try and pursue these dollars, even though no abortion is occurring?
I do not share that concern. Let me put it this way. I am not concerned about that. It might happen, but it's not a concern of mine.
So is that a goal of the bill?
The goal of this bill is to induce compliance with Texas laws.
Okay, but it's creating new Texas law as well to induce compliance.
It actually is sure, we're creating new laws, a new law here. However, we're not changing fundamental abortion laws, Representative Zwiener. What this bill is about is giving us additional mechanisms to enforce existing abortion laws in the state of Texas.
But to be clear, an abortion does not have to happen for somebody to have a claim under this bill, right? There just has to be some level of intent to move the medication into the state.
That is very clear in the bill, Representative Zwiener. The mailing, the distribution, the manufacturing, the providing of these pills, Representative Zwiener, in violation of Texas law, that is the actionable claim here in the Key Tam lawsuit.
And coming back to that claimant relator, they can designate a charitable organization to receive the rest of the penalty under this law, correct?
They not only can, they have to.
Okay. Could a lawyer who works pro bono for a charitable organization designate that charitable organization as the beneficiary of the money recovered from the lawsuit?
If it's a 501c3, the bill is very clear that the relator cannot have an interest, a financial interest in the charity that's chosen, and so in that situation, no, that couldn't happen.
What if a tax-exempt organization, let's just call it Sovereign Love Church, which is not required to disclose its donors under federal law, receives donations under what is called a donor-advised fund, where the relator puts the money or assets into the fund, takes a tax deduction, and then tells that fund where the donations go. You direct your money to go to Sovereign Love Church, except Sovereign Love Church is actually the one who has been paying for the lawyer who is the relator in a case. Because it is not required to disclose its donors, how will Texas taxpayers ever know if the relator designated in the first place?
I don't even know what you just asked me. I'm sorry, I tried to follow you, but I was not able to do so.
I think the concern is whether or not people can use some of these donor-advised funds in order to find ways to funnel money back to organizations that are employing them outside the provisions of your bill.
No, you cannot. The provisions of the bill are clear, Representative Zwiener. The relator cannot have a financial interest in whatever entity it's going to. That's the purpose of the bill.
How would that be enforced for a tax-exempt organization that is not required to disclose its donors?
The court in that situation it's supposed to be held in trust, actually, for the bill calls for it to be held in trust for the benefit of the charity. And so, again, Representative Zwiener, those are so highly factually sensitive and specific that it is impossible here for us to determine how that law might be applied in that situation. Everybody is expected to comply with state and federal law, including all the relevant and applicable tax laws.
Well, with due respect, I do think our job here is to think through all those factual scenarios and make sure we don't have unintended consequences.
And in due respect, I believe that we've done that, which is why we've crafted the legislation the way it's crafted.
I do have one last typo, only one. Let's say the relator is employed by an anti-abortion charitable organization. Can the relator donate 90% of the money to a charitable organization that is not in privity with the relator directly, but does have a financial relationship with the relator's employer, anti-abortion charitable organization? Could they donate to a sister organization for their employer?
Sure.
So if you had, say, a C3 and an action fund that are sister organizations and the lawyer works for the action fund, they could donate that money to the C3 arm.
We expect the law to be complied with, Representative Zwiener. The law is very clear when it comes to what charities can and cannot be chosen by the relenter, and so we expect the bill to be followed.
Okay, and to be clear, the bill as written would allow someone who works for an action fund, who is the relator, to then donate the money to the main organization.
Representative Zwiener, again, with all due respect, without knowing exactly the legal relationship between the entities you're talking about, without seeing the documents, without knowing if it's a 501c3 or a 501c4, I don't.
Well, 50C action funds are generally 501c4s.
Okay.
And then usually the sister organization C3 is a 501c3. So that's the hypo I'm talking. They usually have overlap in boards, but not always.
Sure.
And sometimes overlap in staff. And I'm talking about a situation where the attorney works only for the C4 organization. Could they then donate the money to the C3 organization that shares the same board and operating staff?
Representative Zwiener, I believe so, yes.
Okay.
However, the bill is clear, and the court would be involved in that situation, and we would expect that state and federal law, including this bill, would be complied with by everybody involved.
Thank you.